Wolf Theiss Soundshot. Insights and analysis from one of the leading law firms in Central, Eastern, and Southeastern Europe.
Welcome to another edition of Wolf Theiss Soundshot, the podcast which explores important legal topics in Central and Eastern Europe. Today, we are joined by energy specialist Peter Ihasz from Wolf Theiss Budapest, who speaks with tech and IP expert Flavius Florea from Bucharest regarding Flavius's recent article entitled Artificial Intelligence and the Future of IP Rights. Enjoy the discussion.
Hello and welcome to Wolf Theiss Soundshot. My name is Peter Ihasz, a senior associate from corporate M&A team in Hungary, specialized in technology matters. And I'm joined today by my colleague, Flavius Florea, counsel from our team in Bucharest, specialized in the field of technology and intellectual property law. Hi, Flavius.
Hi, Peter.
Very nice having you here today. Today, we are going to be talking about a very interesting topic. You have very recently published a very interesting article titled Artificial Intelligence and the Future of IP Rights. And Flavius was kind enough to accept my invitation today and join me for a short discussion regarding the connections, the issues surrounding this very current topic, and the use of artificial intelligence, how copyrighted works are created by the use of these solutions and software creations, and what is exactly the case. How does EU regulators, global regulators, look at artificial intelligence? What's the role of it now, and what may be the role of it in the future?
Thank you, Peter. Thanks a lot. I'm really happy to be here, and thanks a lot for your interest in this topic. This is a real actual topic which has created a lot of buzz and a lot of interest around it. I really hope that we'll have a fruitful discussion, and really happy to be here.
Absolutely. Thank you so much. To start things off, could you briefly run us through what do we mean by AI? What do you see as artificial intelligence? Because it's a buzzword, really. And in many cases, I think people confuse it. People think these are robots from the future and they will be taking over the world. But I understand this is really not the case. And if you just give us some insights with respect to what AI is, what that means, and what should we consider when we are discussing AI as a legal concept.
You are right. There are a lot of discussions about what AI means. Generally, we could refer to artificial intelligence by referring to a system that somehow displays intelligent behavior by analyzing its environment and by taking certain actions with some degree of autonomy in order to achieve specific goals. When we think of AI, or when we think of an AI-based system, we can first think of a purely software-based system acting in the virtual world. And here I can think of voice assistants, maybe image analysis software, search engines, maybe speech or face recognition systems. Or on the other hand, we can think of AI as a system embedded in hardware devices. And here we can think of advanced robots maybe, or why not autonomous cars, drones, or IoT devices or applications. There's no clear definition to what an AI system means per se, but a definition has been tried in the new proposal for an AI regulation, which was adopted by the European Commission last year. And there, an AI system was defined as a software developed with one or more predetermined techniques and approaches, which can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions, influencing the environments they interact with. It's a rather abstract definition, I would say, but it becomes a bit more concrete when we speak of the techniques and approaches that are used in this type of systems. So I would say that the main types of approaches or of techniques towards AI are machine learning approaches, logic and knowledge-based approaches, and statistical approaches. I would say that the most interesting or intriguing of this from a legal point of view would be the machine learning approach, which raises some really interesting issues from the perspective of IP rights. And I hope that we can get to that a bit later and talk a bit about this.
Absolutely. Many thanks, Flavius. My question would be, what is then the connection between copyright and artificial intelligence? Because what I see and what I hear is that these software solutions are then capable of learning, of becoming more sophisticated, acquiring certain skills, and then eventually getting into the position or leading up to a point in their capacity to make certain decisions that are very similar to what copyright law prescribes with respect to those human elements, those authorship elements that are generally very defining for copyright eligible works. And what do we see here as a pattern from a legal perspective?
There are several points of connection. There are several situations that are relevant from an IP and copyright perspective in connection with the artificial intelligence. The main points of contact, the main connections between IP and artificial intelligence, I would say that are related upon the copyright or the IP rights over the AI system per se, so over the software that is embedded in the AI system on one hand, and on the other hand, the point of connection between IP rights and AI would be the ownership over the results of the AI generated output of the creations of the AI system. These two topics are the most interesting ones and the ones that raise the most issues. But there are two other important aspects to mention, which are the rights over the algorithms embedded in the AI software on one hand, and the IP rights over the input data, over the data which is fed into the algorithm. So these are the main points and the most important points that raise certain issues from an IP perspective.
And I understand that these algorithms themselves are not protected by copyright.
Indeed, under Romanian law, where I'm familiar with the situation, I can say that algorithms are not protected at all because they are considered to be part of the public domain. Let's say the mere idea is not considered to be original enough in order to benefit from a copyright protection. Let's say the only remedy for owners of algorithms is to protect them under the trade secret. So to ensure that algorithms are protected by trade secret and are treated as confidential information, and that they are not disclosed to any other third parties. But this could generate some problems because those algorithms could be figured out by a third party. So it is not that easy to protect them, I would say.
Right. And then you mentioned just very recently that the creation of copyright eligible materials or copyright itself is very much dependent on the level of inputs that these algorithms may receive, or how these algorithms are trained, for example, in the case of a machine learning algorithm, and the level of details these artificial intelligence software solutions can achieve. And my question here would be, how do you see in terms of Romanian legislation and what you see now on an international scale, can these works created by AI, depending on the level of input received by their developers, be eligible for copyright protection? What would be then the conditions that would have to be fulfilled in order for these works, if they are considered works actually, these works to receive copyright protection, and who would receive such protection ultimately? That's one of my biggest questions.
Yeah, that's a very good question, Peter. And this topic was not in discussion until now because traditionally the ownership of copyright in some computer-generated works was not in question, given that the computer, the software, the computer program was only a tool that supported the creative process. So you can compare it with the pen and paper or with the brush that the painter is using in order to create a drawing. So this is a very good comparison, and the situation was like this until now, until the rise of the AI. But now things have changed a bit, and until now, creative works qualified for copyright protection if they were original, and if until now definitions, let's say the concept of originality, required the human author, now we are starting to see some changes. At the moment, most jurisdictions, including Spain, Germany, Romania, state that only work created by a human can be protected by copyright. But in terms of current legislation, when we determine whether a creation of an AI system could be protected under the currently applicable framework, we must distinguish depending on the degree of involvement of the human creator. And in this sense, we can have AI-generated creations, which would be works generated autonomously by AI systems, and AI-assisted creations. This would be works created by a human author with the help of an AI system. So if we distinguish between them like this, in case of AI-assisted creation, the current legislation could allow the recognition of the authorship of the human created who use the AI system if the degree of human intervention is important enough to be considered a creative activity per se. So in this case, actually, in case of assisted creations, we are in the case of the painter and the brush. The painter uses the brush and the result, the output, is a creative activity per se, and it will be protected by copyright. Well, on the other hand, in case of AI-generated creations, where we have a very limited creative activity, or even, why not, no creative activity at all, the prevailing interpretation in the EU is that at the moment, these categories of works cannot benefit from protection because copyright can only protect, as I mentioned before, works which have a human creator, a human author. This is the prevailing interpretation also in the case law of the Court of Justice of the European Union. The court even stated that copyright only applies to original works and that originality must reflect the author's own intellectual creation. So this condition is somehow interpreted as a necessity of the existence of a human creator. This is the situation in most EU jurisdictions, from what I know. And at the moment, I don't think that the case law can change this interpretation. So I think that we need a new piece of legislation in order to change that. Based on the current legislative framework, we will certainly or most certainly not see any amendments to that. On the other hand, there are some jurisdictions, and I think they are worth mentioning, such as Ireland, Great Britain, and I think New Zealand, that recognized authorship in the person who created the software capable of generating that certain output, that creation. But on the other hand, an interesting discussion will be whether the AI system would be recognized as an author. And here the discussion becomes more complicated because we will talk about legal personality of the AI system. To my knowledge, there is no jurisdiction that recognizes that at this moment. And also there have been some points of view in the European Parliament, if I recall correctly, against this approach. The European Parliament deemed that it is not helpful to recognize the legal personality and the authorship of an AI system for the time being. We are most likely not prepared for that. Let's say maybe in the far future we will see this as a solution, but for the time being, I would say that we would have to focus on whether the author or the creator of the software, maybe, or the owner of the software could be the owner of the IP rights over the output of over the creations of the AI system.
Many thanks, Flavius. That is very interesting. And I think there will be some groundbreaking revolutions in how AI is regulated, or at least potentially how it will be regulated when AI is considered an author or a inventor, for example. But I do understand that differentiation you've just made, and AI generated output is not something that we are so much seeing at the moment, because the AI itself is not so much at the level of being fully capable of making those decisions that will ultimately grant that level of originality and genuinity to the created works, or, for example, a invention, the novelty aspect of that, and how those would receive or be benefiting from protection. And it's not so much visibility on AI generated output that is solely generated by the AI, and all decisions in its creation of the work itself coming from that particular software. But in terms of the AI assisted output, we are already seeing many use cases in our everyday lives where AI software itself somehow enhances the environment, or an already created work, or an already existing literary work or artwork, or even just very simple use cases. For example, DeepL is a machine translation software where there is one direct language input and there's a language output, but the process itself was completely done by some level of autonomy by the AI, and we get a really nice and usable translated texts that is of a quality that we've not really expected to have a couple of years before. So there are already many use cases in our lives that are well represented and forward thinking and forward moving. But at the moment, we are really on the verge of making that additional next step. And of course, the law and the regulators will have to follow and have to keep up, which is always a huge endeavor for the regulators themselves and market players as well. Moving on to the next question, we've now discussed works created by AI, or at least partially created by AI or assisted by AI, whatever the case may be. But we've not discussed a very interesting question. What happens when the AI is using data from somewhere, either on the internet or from whatever source really, and then uses that collected input to compile and create the work it was tasked to do? And of course, in a controlled environment, the programmer or the author itself, who is then feeding input into the AI, may control and consider what kind of protection the input data is actually having, so not to infringe on other people's AI. But what's the case when we allow the AI to roam free on the internet and to collect whatever input it deems best or finds most fitting into its algorithm? How do we see, and how does the law see at the moment any such potentially infringing behavior by such algorithms?
This is also a good question, Peter. As you mentioned, AI systems and specifically machine learning systems will always learn from the data available to them, from the data we make available to them, or the designer of the system makes available to them. And this could easily include works but protected by copyright, like books, maybe like paintings, like music or photographs. We cannot have a discussion about AI without mentioning the next Rembrandt project. In this project, an AI system was trained to develop a new painting in Rembrandt style, and this system used data from 350 almost of Rembrandt's works to do so. This system generated very popular painting, which resembled a lot. I actually looked like a Rembrandt would look like, but it wasn't actually a Rembrandt. We have another useful example about Google's AI Quick Draw. In this case, AI attempts to identify doodles drawn by users. This has been used more than 50 million times, and the AI system improves as it learns from each doodle. These are very typical examples of works used by an AI system which may be protected by copyright. Basically, under the current legislation, this would mean that the copyright owner's permission is necessary in order to use the works lawfully. Maybe the only situation where we could use these works lawfully without the copyright owner's permission would be the case where an exception applies, like the fair use doctrine, as you mentioned. This permission may be granted either by using a license, or we can identify a fair use case and apply it accordingly. But in most jurisdictions, and Romania is one of these jurisdictions, the fair use cases are not applicable to AI systems. So this would mean that copyright is generally infringed when someone uses a substantial part of a work without the owner's permission. And here, if we start making a comparison with the classic authorship, let's say, copies made inside the human brain do not infringe copyright, but copies made or stored or used by an AI system, by an AI software with the help of a computer, based on the current legislation, they infringe copyright. So a person may remember a song, for example, and sing it in their head without infringing copyright, but if the song is performed in public without a permission, then this would infringe copyright. And actually, this is what the AI system does. It performs the song in public. This is what it does, or at least a part of that song. So as I was mentioning, copies made by the AI system generally infringe copyright because the information is stored within the AI system's memory. And an AI system may also infringe copyright by generating copies of the works externally, by showing it to the public. And when copyright is infringed, then the copyright owner would have the right to take action. And this means that when an infringement takes place, when an AI system infringes copyright, someone, a person or a legal entity, must be responsible. And generally, I would say that the liable person should be the person who controlled the infringement, who generated the infringement, and who has the ability to stop it. In this respect, I think that under the current legislation, the owner or the person who has control over the infringement will be liable, and that in respect of the future, we could think of potential solutions, that we could think of whether the input data for an AI system should benefit of the fair use doctrine. But I am not sure whether this would be a very responsible solution, let's say, because this would mean that you can use any type of copyrighted works in order to generate a new one based on that work. And with a minimum effort, you could generate a new works which could be easily used by third parties instead of the original works created by human authors. So this would somehow create a disadvantage towards human authors. A disadvantage which would be significant given the fact that an AI system can generate numerous or endless types of creations, and it could work continuously, while the human author could not do that. And think about what this would mean, for example, for web design. What it would mean if a website designer should compete with an AI system for the customers. And if this competition, if an autonomous AI system could compete with a human author, I think that in the future, definitely the AI system would win and could create comparable outputs and in a much shorter period of time. But it wouldn't be fair, I would say, to allow this, because the work of the AI system will be ultimately based on numerous hours spent by a human creator. So I would say that a licensing system maybe would be better in this case than the application of the fair use doctrine in this respect.
Well, most definitely, I fully agree with you. The fair use doctrine is much more of a concept created for non-economical uses of copyrighted works or other works that are protected by certain IP protections, and definitely it's for the greater good of the public domain and for the use of education or the self-education or mass education or really just for other socially beneficial use cases, not for the clear economic benefit of the market player, really. And that is exactly why these machine learning setups may become abusive, in the sense that you mentioned, that if you allow them just really scouring the internet and cherry picking whatever nice elements they see from certain websites, either graphical elements or other mechanics, then it really just becomes a malicious software, a spider that basically just collects all these elements unlawfully and then uses them to create products that would normally require a licensing setup. So definitely, I agree with you. And so jumping to your article a bit here, Flavius, which is very interesting on this particular topic, you mentioned here that it would be beneficial to propose and implement differentiated systems of protection for these AIs. And I'm wondering, how would you envisage the system working? What benefits would it have against the current non-regulated approach, considering the risks that we've just discussed with respect to abusive behaviors?
Well, first of all, besides the risk of abusive behaviors, we don't have to forget that any proposed system should somehow resolve the incompatibilities between the classical copyright system and the AI. There are certain things that are just not compatible, and the first thing that came to my mind is the duration of protection for copyright. In most EU jurisdictions, the duration of protection is of 70 years from the death of the author. So the copyright, the works of a certain author are protected for the lifetime of the author and 70 years after his or her death. And this is purely not applicable in case of an AI system. So we really cannot think of any manner in which we could apply this. I cannot think of any manner in which we could calculate the duration of protection. We can apply it to AI assisted works where the author is the person that enabled the AI system to create the work. So there it would be easy, but for AI generated creations, we cannot really apply this. Another issue is the issue of the moral rights. The moral rights are widely recognized and are a very important component of the copyright. And in case of AI system, we cannot talk about any more moral rights. So this should be also solved somehow. So I would see the best solution that I can hear is a solution similar to the protection of databases in certain EU jurisdictions, where the manufacturers of databases are granted the sui generis right over the database that they have manufactured. So if you ask me, this is not the most inspired name. So maybe in case of AI, we can find a better a better name for the rights related to AI generated works. But other than that, I think that a similar system could also work in this case.
Absolutely. And as a final question to conclude our conversation and our chain of thought, how do you see recent trends in this area? Because, for example, you've mentioned the Rembrandt painting, which is a very interesting case that came up. And what other recent cases you have seen in this area now? And what are the current developments in this area of law? You mentioned these potential regulations and potential ideas for regulation. Is this something that is already ongoing? Do you see any examples for this, either in the EU, the UK, or even the US, as they are usually the flagships of these areas? Or how do you see the future of AI being regulated, either in terms of being granted copyright protection or as a potential infringer of copyright?
Well, as you know, we have a proposal for a European Union regulatory framework on artificial intelligence. So we have a proposal for regulation on this. But while this will create a process for self-certification and also a process for government oversight of many categories of AI systems, of high-risk AI systems, and will also create transparency requirements and attempt to ban a few unacceptable qualities of AI systems. However, this does not tackle at all the relation between AI and IP rights. We also have a more recent proposal for a directive from the EU Commission on AI liability, and this is a very good development, I would say, because it aims to ensure that any persons harmed by artificial intelligence systems enjoy the same level of protection as persons harmed by other technologies. So this is a very good thing because it will determine who will be liable for what. And this could have potential applications, let's say, toward the liability for copyright infringement. But other than that, we do not have anything in place right now on IP rights. There have been a lot of discussions, especially at the level of WIPO, the World Intellectual Property Organizations. A lot of documents that were generated in this respect, and a lot of discussions, but we don't have a clear solution yet. There are still a lot of problems to be solved. There is a huge debate on whether an independent system of protection for AI generated works would be better, or other opinions are in the sense that copyright system with certain exceptions in relation to the incompatibilities that I have mentioned, that a copyright system would be better and that we don't need such new rules. And there are arguments for and against any type of approach. Of course, the copyright system is very well sedimented, let's say, and we have a lot of precedents that could help us determine which is the right or wrong approach, but we should not forget that many of them could not be applicable in case of AI, because AI is a new technology and AI does not resemble that much to the human mind, let's say. But as I was mentioning, in the process is rather similar, but in reality, the AI, we must not forget this. An AI system could generate almost a limitless number of works. So if we allow AI systems to, let's say, use copyrighted works as the human created would be able to use them, we would create an unfair competition, I would say, in this field. On the other hand, I don't agree with the approach towards not granting any type of protection to AI generated works, because this would not encourage the progress in this domain at all. So we have to think of some sort of protection for AI generated works, and I think we will see it at some point soon in the new legislation. I actually expect to see something from the EU Commission in the next couple of years. So I would be really surprised if we don't have anything in the next 2 years on this. At least a proposal, not the finalized legislation. Maybe we could expect of something finalized in the next 5 years, let's say, but I think in the next 2 years we will have at least something at the proposal level.
Very much seems that our work is cut out for us, definitely. And we will see some very rapid changes and interesting developments in this area of law. I do see also that the European Intellectual Property Office has also published a study on the impact of artificial intelligence and the infringement and enforcement of copyright. So definitely it's on the radar. Regulators are looking at it, not just on the EU level, but definitely locally as well. And the tech world is also buzzing. AI is definitely appreciated. The use cases are definitely there, starting from autonomous driving to assisting design, to translating programs, to enhancing environment, to helping us think, helping us create more value and develop and really progress into the future as we hope to do so. AI will be with us. We don't quite know how to develop to a level that may match our own intellect in the sense of its genuinity, not in the sense of its capacity, because as you mentioned, limitless power is something already available to them. But for the level of creativity is something that hopefully an element that remains with us humans for a while still, and let's just see how things will change for the better or for the worse, hopefully for the better. Flavius, I very much thank you for your time and thank you for this very interesting discussion. I learned a lot, and I think we opened a lot of questions that we may want to answer at a later stage in another podcast. Definitely for now, I thank you for your time and thank you for being here, and hope to see you next time.
Thanks, Peter. Thanks for having me. It was my pleasure also. Hope to have another discussion at some point soon.
Thank you for joining us for this episode of the Wolf Theiss Soundshot. For more information, you can contact us via email at soundshot@wolftheiss.com or visit our website at www.wolftheiss.com. You can also follow us here to receive further updates on developments in law and business from one of the leading law firms in Central, Eastern, and Southeastern Europe.